Okay, hello, welcome to Win Without Law School. I'm Arizona lawyer Julie Labenz. Today, we are going to be talking about discovery in the context of a divorce or legal separation case. And let me get my slides up. Here we go. First of all, what is discovery? Well, discovery are a series of legal tools that we're going to discuss today that you can use to obtain answers, information, and documents relevant to your case. Now, in the last week, we talked about disclosure, and disclosure is controlled by Rule 49, and it's the documents and information that each side is required to share throughout their case, whereas discovery is a series of legal tools available to both parties to use to obtain answers, information, and documents relevant to your case. What are the discovery tools? Well, there's a subpoena, interrogatories, which can be uniform or non-uniform. Interrogatories are a series of questions. The uniform interrogatories are a series of questions that have been created to be asked in family law cases, in particular in a divorce case. And then non-uniform interrogatories would be interrogatories you create on your own based on questions you have for the other side about your case. The party responding to the interrogatories has to answer under oath. So their responses can be used at trial or later in the case because it is a sworn response. A request for production, this is another discovery tool. This is where you can ask the other side to produce records. Also under a request for production, you could request access to property to inspect it. So let's say in your divorce, one spouse has exclusive use and possession of the marital home. And within the marital home, there's a safe where you kept cash, marital cash during your marriage. And you want to inventory what's in the safe. Well, you could potentially do that through a request for production saying, here's a date and time. I propose to come onto the property for the purpose of accessing the safe and inventorying what's in there. So that's one example. Another type of discovery tool are requests for admissions. This is where you ask yes or no questions, true or false, and get a response from the other side. So interrogatories are any type of question. Request for production is to get documents or to inspect. And then a request for admissions is the yes or no or the true or false questions. Then there's a deposition. This is where you meet with the person you want to depose. By depose, that means ask them questions under oath in a setting that's recorded. So a deposition is where you set a date and time to meet. It usually takes place in a conference room. A court reporter can be there or it's otherwise recorded. The person to answer the questions is put under oath, and then questions are asked and it's all recorded and documented, and it eventually is put into a deposition transcript, and that can be used throughout the case and in a contested trial. Evaluations, these can be mental evaluations, physical evaluations, vocational evaluations. The vocational evaluation, that's about what type of work somebody's qualified to do. And that is generally within the spousal maintenance context. So if there's a question about whether or not somebody can go back to work and what they could earn, there could be a vocational evaluation requested and then performed where an expert makes that determination. What are the grounds to object to a discovery request? So let's look at the scope and the limits. In general, the scope is defined as follows. So this is from the Arizona Rules of Family Law Procedure, and this is within Rule 51. So we're at Rule 51B. And it's talking about how parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. Written discovery to a party may not request information that party is required to disclose under Rule 49. So one objection, as we're seeing here, is this is privileged. What is privileged? Attorney-client communications are privileged. Attorney-worked product is privileged. So there can be certain objections made based on privilege. Also, we're seeing here non-privileged matter that is relevant. So there could be an objection based on relevancy. And then proportional to the needs of the case, there can also be this objection on proportionality. When we look at proportional to the needs of the case, what would that mean? Well, let's say somebody's requesting records that go back for 10 years. Yet, is that really valid in this type of marriage? So really looking at, are 10 years of records relevant in proportion to what's at issue in the case? Then there's the limits on discovery. So discovery, so let's see here. The court can limit the frequency or extent of discovery if it determines that the discovery sought is unreasonably cumulative or duplicative, or can be obtained from another source that is more convenient, less burdensome, or less expensive. So let's say you're served with a discovery request for records from a joint bank account, and your spouse has equal access to those records. You could object saying these records can be obtained from another source that's less convenient, that's more convenient, less burdensome, and less expensive because you can just get them directly. Unreasonably cumulative or duplicative, if they're asking for the same records over and over again, and you've already produced them. And then number 2 here is seeks information that the party has had ample opportunity to obtain. So again, if these are records that each party has equal access to, you could object to that. Or that the discovery is outside the scope of Rule 51B1A, which is right here, this scope paragraph, which we just covered. And then there's this specific rule for electronically stored information. A party need not provide discovery or disclosure of electronically stored information from sources that the party shows are not reasonably accessible because of undue burden or expense. So if you're dealing with electronically stored information and this is coming up in your case, definitely review this rule in more detail. Let's talk about privilege or work product. When a party withholds information, a document or electronically stored information in response to a written discovery request on the claim that it is privileged or subject to protection as work product, the party must promptly identify in writing the information, document, or electronically stored information withheld and describe the nature of that information, document, or electronically stored information in a manner that, without revealing information that is itself privileged or protected, will enable other parties to assess the claim. So you're not going to be able to just say objection privilege or objection work product. You'll need to promptly identify in writing exactly what you're withholding without revealing the privileged aspect of it. Also, keep in mind that if you have responded to a discovery request, you must supplement or correct your response if you learn that your response was or has become materially incomplete or incorrect. And if the additional or corrective information has not otherwise been disclosed to the other parties during the discovery process or in writing. In no event more than 30 days after you learn that the response is materially incomplete or incorrect, that you need to supplement or correct it. So bottom line, if you do a response and you realize later you need to change it, then you need to do so, and you need to do it within 30 days. Okay, now let's look at a subpoena. Let's look at how to request one, what types of subpoenas there are. Let's look at what your options are as far as using a subpoena as a discovery tool. A subpoena is a court order to produce documents or to appear in court to testify. So we have two types of subpoenas. The subpoena for documents, which is called the subpoena ducis tecum, or a subpoena to testify, which is generally just called a subpoena. But there's two ways you can utilize a subpoena, either to produce documents or to order somebody to appear in court to testify. So regarding the subpoena for court to produce documents, this is where you could subpoena records from a bank or a credit card company or a mortgage company. You know, if you're looking to get records related to marital assets or debts, you can, as one potential avenue, use a subpoena. Also, if there's a witness that you want to testify in court and they need a subpoena to get out of work to get there, or they won't appear without a subpoena, then you can get a subpoena and serve it on them for them to testify. Let's look at some types of records. This is not an exhaustive list, but some types of records that you could obtain via subpoena. Bank records, credit card records, investment, brokerage account, retirement account records, counseling records. Those are some examples. Let's talk about how to fill out the subpoena form. So if you're going to make a request for records using a subpoena, what are some of the best practices for filling out the form? Well, number one, make sure that you have the name of the appropriate person or department for the subpoena to go to. Make sure you have the correct address. If you're dealing with a big corporation, some of them have separate particular addresses for service of a subpoena. So you'll want to do some research to see if, for example, the credit card company you're going to serve a subpoena on, to find out what is their mailing address for purposes of receiving a subpoena. You also need to use very clear and precise language in describing the records you are requesting be produced pursuant to the subpoena. For example, records for the last 5 years for all accounts in husband's name, and list out what husband's name is. You need to be clear. What records are you requesting? Identify the account number, the name of the account holder. You can provide identifying information like the last 4 digits of a social security number. But the bottom line is you need to be very clear about what records are you requesting, whose records are they, and what's the scope? What are the dates you wanting for the records? So be very clear in your description. Also, you need to provide a deadline for the records to be produced, and you need to allow at least 14 days. Also, be very clear as to how you want the records to be produced. Do you want them to send them to you via email? And if so, you need to give them your email address. Do you want them to mail you the records? If so, you need to provide a mailing address. And be aware that in particular, if you're doing by mail, they can charge a fee for the time and expenses they incur. Even if you go by email, there still could be a fee for them gathering the records and organizing things for you. The fees are generally pretty manageable and pretty small, but just keep in mind that, through this subpoena process, you could end up paying some sort of fee to the company that's producing the records for you. This is the standard form for a subpoena for the Maricopa County Superior Court. So you'd fill out your caption. And then when I was saying, have the correct name and address, you want to have that specific information here. This is the box to check if you're looking for a subpoena for a witness to testify. And then this is the box to take if you're looking to order somebody to appear to testify at a deposition. And then here's the box for a subpoena ducis tecum. This is for records. So here's where you list out exactly what you're wanting to be produced, and then the details about how you want the documents produced. And so this is where you could say via email and provide your email address, or via mail, provide your address. And you can indicate the date that you want the documents back by. Once you fill this out, you take it to the clerk to be issued, dated, and signed by the clerk. You'll need to include all 6 pages here when you serve the subpoena. Here's some final signature parts for the court. And then after you've filled this out, you've taken it to the court has issued it, you need to provide a copy to the opposing party. And then you need to serve the subpoena on the person you want to appear to testify or upon whoever you're asking to request documents pursuant to the subpoena. Now, if you're looking to, for example, subpoena records from a bank, and there's a branch of the bank down the street, you could potentially take your subpoena for records from that bank, have somebody who is not a party to your case and who's at least 18 years old, take the subpoena to the bank, serve it on them, and then you could do a proof of service to that effect. You need to provide a copy of the subpoena to every other party in your case. The subpoena can be served anywhere within the state of Arizona, and then you'd want to do a proof of service. So let's just look at the steps. Number one, submit the completed subpoena form to the court clerk, pay the subpoena issuance fee, which I believe is $40 to the court, serve the subpoena. Also, prior to service, you need to provide a copy to the other side. So submit the subpoena form to the court clerk, pay the fee, send a copy of the subpoena to your opposing party, serve the subpoena, and file proof of service with the court. Now, let's say the hand delivery method isn't going to work for you. Maybe the company you want to serve the subpoena on is out of state, or, there could be a number of logistical reasons why the hand delivery wouldn't work. Here's some other options. Acceptance of service, which is where the person fulfilling the subpoena signs that, yes, I've received a copy of the subpoena, signs the acceptance before a notary, and that gets filed with the court. You can do the certified mail restricted delivery. So mail a copy of the subpoena to the company or to the person you want to testify. And when they sign the green card, service is complete, you file with the court proof of service. Or you can hire a process server. So here is the standard form for affidavit of service and subpoena. If you're doing like the hand delivery route, when of course it has to be a non-party, so it can't be you doing the hand delivery, but you work with somebody else to handle it. This would be the form to show proof of service that way. Otherwise, you can use the acceptance of service form. You'll need to write in here the subpoena. That's what you're serving, because there's a box for that. And then these paragraphs don't apply to 3 and 4, so cross those out. And then the person accepting the subpoena signs here before a notary. And then the affidavit of service by mail. This is also called the affidavit of service with signature confirmation. This is where you indicate how you did the certified restricted mailing. Again, list your subpoena document here, sign, and then this is where you attach a copy of the signed green card and a copy of your mailing receipt. Okay, so that was a subpoena. Another type of discovery tool are these interrogatories, and they can be uniform and non-uniform. So this is under Rule 60 of the Arizona Rules of Family Law Procedure. Interrogatories are written questions from one party to the other that are answered in writing and under oath. You're limited to 40 written interrogatories. For a uniform interrogatory and its subparts, that's 1. But if you're doing a non-interrogatory, then any subparts are a separate interrogatory. Uniform, the whole set of uniform interrogatories is in Arizona Rules of Family Law Procedure, Rule 97, Form 7, and I'll show you that form. The bottom line is you need to go through the uniform interrogatories and pick out the questions that you want to be answered. You shouldn't just serve the whole thing, because not every question is necessarily going to apply in your case. So you need to go through and tailor it first. Non-uniform interrogatories are served on the other party, and you serve them by mail or email. Generally mail, you'll only do email if the other side has agreed to accept service via email. Uniform interrogatories, those are served. The standard way to do this is to take all of the uniform interrogatories, print them all out, and then do a separate document called Notice of Service. And in there, list out which numbers of the uniform interrogatories you want the other party to answer. However, another way you can do it is just to tailor the uniform interrogatories to the exact questions you want answered. So either you can do the Notice of Service with the numbers, or you can just take the uniform interrogatories document in Word form and tailor it so that all that's left are the questions that you want answered. You don't file anything related to interrogatories with the court. Regarding responding, so if you're served with interrogatories with the petition for dissolution, you have 60 days to respond. If you were served after you've already responded to the petition, then you have 40 days plus 5 days for mailing. So you have 45 days from service. Your answers must be under oath. If you object, you need to state your objection with specificity. You need to sign at the end saying, yes, I'm signing these under oath. If an attorney objects to any interrogatories, the attorney must sign the objections. And then the service, the answering party must serve the original answers with any objections on the propounding party and must serve a copy on every other party who has appeared in the action. The answering party must not file interrogatory answers with the court. So nothing gets filed with the court. It's just exchanged between the parties. An answer to an interrogatory may be used to the extent allowed by the rules of evidence. Since it's under oath, interrogatory response can be used in court. Option to produce records. If the answer to an interrogatory may be determined by examining, auditing, compiling, abstracting, or summarizing business, medical, mental health, behavioral health, employment, income tax, or education records, and if the burden of determining the answer will be substantially the same for either party, the responding party may specify the records that must be reviewed in sufficient detail to enable the interrogating party, interrogate, it's a hard word to say, interrogating, yes, and I had that right the first time. I shouldn't have second guessed myself. To locate and identify them as readily as the responding party could, and give the interrogating party a reasonable opportunity to examine and audit the records to make copies, compilations, abstractions, or summaries. So there is this objection that can be made and this option to produce triggered. So keep that in mind. If you have something that's really voluminous and needs to be summarized. All right, here are the uniform interrogatories, and everything that's in red needs to be tailored to your case. These are the instructions for use. And then here are the actual interrogatories. So this is what you need to go through and delete anything that doesn't apply in your case. So if any information that you're not wanting, or for example, let's say you have a case that is a divorce without minor children, then a bunch of these questions about children you should not include. Also, let's say you and your spouse have already worked out your parenting issues, then you wouldn't need to ask these questions. So again, go through this and tailor this specifically to what you want. You don't have to use this document. This is just optional. If there's any evidence and information that you haven't received through Rule 49 and that you believe would be relevant and helpful to your case. All right, now regarding serving interrogatories, you mail the original in one copy to the opposing party and their attorney. And then service, unless you receive the interrogatories with the petition for dissolution, and in that event, you have 60 days to respond. But if you receive it after you've already responded to the petition for dissolution, then you have 45 days to respond. All right, now let's look at a request for production of documents and things. This is under Rule 62. A party may serve on any other party a request for production. And this is to produce and permit inspection, copying, testing, or sampling of items in the other party's possession, custody, or control. So this can be for documents, it can be for tangible things, or to permit entry onto designated land or other property possessed or controlled by the responding party, so that the requesting party may inspect, measure, survey, photograph, test, or sample the property or any designated object or operation on it. So you can see it's not just documents, you can also inspect. As far as numbers, there should be no more than 10 items or 10 distinct categories of items. And then in your request for production must describe with reasonable particularity each item or distinct category of items to be inspected, must specify a reasonable time, place, and manner for the inspection and for performing the related acts, and may specify the form or forms in which electronically stored information is to be produced. It's the same response deadline, 60 days, if you were served with a request for production with the petition. Otherwise, if the response has already been filed, then it's 45 days, 40 days plus 5 days for mailing. For each item or distinct category of items, the response must either state that inspection and related activities will be permitted as requested, or state the grounds for objecting with specificity, including the reasons. An objection must state whether any responsive materials are being withheld based on that objection. A party objecting to part of a request must specify the objectionable part and permit inspection of the other requested materials. So you need to narrow down your objection and then allow inspection for the things that aren't being objected to, and then withhold what's being objected to. And then for electronically stored information, there are some additional rules. So take a look at that if that's something that you are dealing with. Here is a sample of a request for production of documents and things. Again, you'll need to fill out the red parts. This is set up to receive the documents via email. So if that's not what you want, you'll need to tailor this and list your address. Here's the instructions, and then here's the documents to be produced. So income information, investments, banks and other financial institutions, debts, real and personal property, gifts, loan transactions. So all of this stuff listed in here is not going to be relevant in every case. So if you're looking to have documents produced, look at this and tailor it. And you can also write out your own request if there's something specific that you're wanting the other side to produce. How do you serve a request for production and how do you respond? You serve by mail. You send the original in one copy to the opposing party or their attorney. And then if they receive the request for production when they're served with the petition, they have 60 days to respond. Otherwise, it's 45 days. Okay, request for admissions. This is Rule 64. This is another discovery tool. This is a written request to admit, for purposes of the pending action only, the truth of any matters relating to facts, the application of law to fact or opinions about either, and the genuineness of any described documents. A request to admit the genuineness of a document must be accompanied by a copy of the document. You're limited to 25 requests for admission. And the response time is the same, 60 days if the request for admission was served with the petition, otherwise 40 days plus 5 days for mailing. If a request is not admitted, the response must specifically deny it or state in detail why the responding party cannot truthfully admit or deny it. A denial must fairly respond to the substance of the request. A party must state grounds for objecting to a request. A party may not object solely on the grounds that the request presents a genuine issue for trial. The requesting party may move to determine the sufficiency of a response or objection if it's not clear. And then if you're served with a request for admissions and you admit any of the questions, then a matter admitted is conclusively established unless the court on motion permits the admission to be withdrawn or amended. So for service, same thing, via mail, the original in one copy to the opposing party or their attorney. The response is due in 60 days if you were served with it with the petition, otherwise 45 days. Okay, depositions. A deposition is initiated through a notice of deposition. Unless all parties agree or the court orders otherwise, a party who wants to depose a person must serve written notice to every other party at least 10 days before the date of the deposition. The notice must state the date, time, and place of the deposition, and if known, the deponent's name and address. How can a deposition be recorded? Testimony under oath or affirmation must be recorded by a certified reporter, and in addition, may be recorded by audio or audiovisual means. Transcription. Any party may request that the testimony be transcribed. If the testimony is transcribed, the party who originally noticed the deposition is responsible for the cost of the original transcript. Any other party may, at its expense, arrange to receive a certified copy of the transcript. The parties may agree or the court may order that a deposition be taken by telephone or other remote means. And then for duration, unless the parties agree or the court orders otherwise, a deposition should be of reasonable length, is presumptively limited to 4 hours, and must be completed in a single day. An unreasonable refusal to extend deposition time may result in sanctions. Okay, now let's look at evaluations. This is our final discovery tool. This is under Rule 63. The court where the action is pending may order a party whose physical or mental condition or ability to work is in controversy to submit to a physical examination, mental or behavioral health examination, or a vocational evaluation by a physician, psychologist, or designated expert. The court has the same authority to order a party to produce for examination a person who is in the party's custody or under the party's legal control. So in order to ask the court to order an evaluation, it starts by filing a motion. So it's motion for evaluation, and within that motion, you would need to show good cause for why the court should order the evaluation, and then provide notice to all parties in the case and the person to be examined. If the parties are in agreement that the examination should take place, then the parties could file a stipulated motion for evaluation. Also, the court on its own motion can order an evaluation. We have a question about who assigns the physician. So the person requesting the evaluation generally says who they would like to do it. The other side can then respond and either agree to who the requesting party proposed, or can propose somebody else. And I'll show you in a second some additional rules about that when the parties don't agree. The order ordering the evaluation must specify the time, place, manner, conditions, and scope of the examination, and must specify the person or persons who will perform the examination. So if you want to request that your spouse or co-parent, this is a divorce context, so this would be your spouse. If you want to request that they be evaluated, you would draft and file a motion for evaluation explaining the type of evaluation you are requesting and why there is good cause for the evaluation. You would draft and file a proposed order for evaluation specifying the time, place, manner, conditions, and scope of the evaluation and who you want to perform it. You'd mail a copy of your motion and proposed order to your co-parent or their attorney. Your co-parent or their attorney can file a response to your motion, and then you can file a reply to their response. And then the judge can grant or deny the motion for evaluation, or the judge could set oral argument on the motion and then rule on the motion. Now, what happens when the parties agree that an examination is appropriate, but don't agree on the examiner? In that case, the party seeking the examination may proceed by giving reasonable and not fewer than 30 days written notice to all other parties, identifying the party or person to be examined, the time, place, and scope of the examination, and the identity of the examiner or examiners. After being served with the notice, the party who objects to the examiner may file a motion in the court where the action is pending. For good cause, the court may order that the examination be conducted by a designated expert other than the one specified in the notice. Unless the party has filed a motion, the party must appear for the examination. If a party fails to appear for an examination that's been ordered, then the court can institute sanctions. Evaluation. I mean, the question was about, the scope of an evaluation. And as we saw a few slides back here, and I'll go back to show, when we look at what types of evaluations, the court where the action is pending may order a party, okay, so that would be one of the spouses, whose physical or mental condition or ability to work is in controversy, to submit to a physical examination, mental or behavioral health examination, or a vocational evaluation. The court has the same authority to order a party to produce for examination a person who's in the party's custody or under the party's legal control. So children would fall under, someone who is under the party's custody or legal control. So what this rule is saying is that the court has number one, the court has the ability to order either party, and then also could order children to submit to an evaluation. And that evaluation could be physical, mental, behavioral, or vocational. All right. So let's move back to where we were here. Regarding physical or vocational exams, the person to be examined at a physical or vocational exam has the right to have a representative present and to make a video or audio recording of the examination unless the court has ordered otherwise. But for a mental or behavioral health exam, the person to be examined may not have a representative present and may not make a video or audio recording of the examination unless the examiner agrees or the court orders. So physical and vocational exams are treated differently than mental and behavioral health exams as far as having a representative present and being able to video or audio record the exam. A copy of a recording of an examination must be provided to any party upon request. Once an examination is completed, the examiner will create a report. That report must be in writing and set out in detail the examiner's findings, including diagnosis, conclusions, and the results of any tests. The party who is examined or who produces the person examined may request the examiner's report and written or recorded notes from the examination. If such a request is made, the person who moved for or noticed the examination must, within 20 days of the examination, request whichever is later, deliver to the requester copies of the report and all written or recorded notes, and must provide access to the original written or recorded notes. And then, absent good cause, a party who is examined must disclose reports of all other examinations for the same condition, except for a vocational exam protected by work product privilege. An examination conducted under this rule does not constitute a waiver of any privilege that the examined party is otherwise entitled to assert under law. When do you have to respond to a discovery request? So just a reminder, for a subpoena, it's at least 14 days. The response deadline should be listed in the subpoena. For interrogatories, it's 45 days unless they were served with the petition. In that case, it's 60 days. Request for production, same thing, 60 days if it was served with the petition, 45 days otherwise. Request for admissions, the same, 60 days if served with a petition, 45 days otherwise. Can I request the examination be in Spanish? Other party is requesting court. I submit to a mental health evaluation. Yes, you could request that. If that's the language you're most comfortable with, you could request that an interpreter be present to make sure that you're properly understanding exactly what's being asked and answering properly. Do you file anything with the court related to discovery? With the subpoena, you do take the subpoena form to the court so that the court can issue it. You mail a copy to the other side and you file a proof of service with the court. Interrogatories are not filed with the court. A request for production is not filed with the court. A request for admissions is not filed with the court. Okay, and then we are now at the summary. So just as a reminder, let's look at disclosure versus discovery. Disclosure are documents and information you must disclose pursuant to Rule 49, whereas discovery are legal tools available to request additional answers, information, and documents relevant to your case. Discovery is optional. You don't have to do it. Here's a summary of the discovery tools. There's a subpoena, interrogatories, requests for production, requests for admissions, the deposition, or evaluations. And then just a final question here is, are the evaluations filed with the court? The motion for evaluation, the order for evaluation, all of that would be filed with the court. The evaluation itself is generally not filed with the court. That would be produced as an exhibit at a trial because it would need to be admitted into evidence and testified to and have all the proper foundation filed. So unless there's some specific order from the court that it be filed with the court, generally it's not, and it would be presented at a trial as an exhibit. Okay, thank you for joining us today. That ends today's recording. Please bring your questions to the Q&A.